So I'm going to do a quick video on how California Rules of Court 1.100 regularly discriminates against individuals with disabilities and regularly creates an obstacle for people with disabilities to receive equal access and accommodations under the ADA. This is a pattern of discrimination. And in my opinion, as a non-lawyer, it should be pursued as Monell claims on any case that you're on if you get denied more than once. Um, let's get into it. California Rules of Court 1.100 is absent compliance with the ADA in several ways. The rule does not require compliance with the ADA and actually says that the court must consider, but is not limited by, the provisions of the Americans with Disabilities Act of 1990, 42 U.S. Code 12101 and following. This is in Rule 1.100E1. Let's look at that. In determining whether to grant an accommodation request or provide an appropriate alternative accommodation, the court must consider, but is not limited by, the provisions of the Americans with Disabilities Act of 1990 and other applicable state and federal laws. So in other words, they're giving their rule paramount authority here. And that's discriminatory, denies equal access, and is in direct violation with the ADA. The rule requires a statement of the medical condition that necessitates the accommodation. This is found in Rule 1.100C2. Nothing in the ADA Title II requires a statement of the medical condition that necessitates the accommodation. Now, I already know I'm going to get haters on this that say, you should have to prove your accommodation, you have a situation that needs an accommodation. In federal court, when you go to federal court with claims, you do have to have a prima facie case for that. But if someone who's deaf has to come in and prove that they're deaf, or someone who's blind has to come in and prove that they're blind, or someone who can't walk has to come in and prove that they can't walk, how do they do that every time without extreme prejudice and bias against them? It's just not what the ADA is for. And people who say the ADA is taken advantage of, not in this situation. Request for accommodation must include a description of the accommodation sought, along with a statement of the medical condition that necessitates the accommodation. The court, in its discretion, may require the applicant to provide additional information about the medical condition. This is highly intrusive and is not required under the ADA Title II. And this is an intimidating piece of rule that the court uses to interfere with the equal access of individuals with disabilities. This is 28 CFR 35.101. I'm going to look at paragraph B here, and I'm going to look at the last sentence. The question of whether an individual meets the definition of disability under this part should not demand extensive analysis. The people who are abusing the ADA in this case are the courts. I mean, I've done this for 7 years, and I've seen one court comply with the ADA in 7 years. One court. So, and I do this all the time. So, this is my life's calling, and this is why. Plainly put, California Rules of Court 1.100 affect eligibility criteria that screen out or tend to screen out an individual with a disability or any class of individuals with disabilities from fully and equally enjoying any service, program, or activity. That's found in 28 CFR 35.130B8. It's prohibited to set up eligibility criteria that screen out individuals with disabilities. And that's what this rule does. The patterns of denial in this matter in violation of the ADA also yield Monell claims. The policy, custom, or practice of using the California Rules of Court Rule 1.100 to deny ADA claims is the moving force behind the constitutional violations of due process, equal access, and ADA compliance. There you go. That's a freebie. This is not legal advice, and do your own research.